विविध कायद्यावर या ठिकाणी मार्गदर्शन करणार आहे. माझ्या माहितीप्रमाणे विधिमंडळ परांड्याच्या इतिहासात अशा प्रकारचा कार्यक्रम आपण बारमध्ये पहिल्यांदाच घेतोय आणि आपण आम्हाला मार्गदर्शन करताय त्याबद्दल विधिमंडळ परांड्याच्या वतीने मी आपलं हार्दिक स्वागत करतो. तसंच या कार्यक्रमासाठी आवर्जून उपस्थित श्री जगताप साहेब निवडुंगे मॅडम यांचंही या ठिकाणी विधिमंडळ परांड्याच्या वतीने मी स्वागत करतो. विधिमंडळ परांडाचे नवनियुक्त आजच अध्यक्ष झालेले आहेत सन्माननीय श्री माने साहेब यांना मी अशी विनंती करतो की त्यांनी साहेबांचा हार्दिक स्वागत करावं. मी माननीय श्री ख्वाजासाहेब शेख साहेब यांना मी अशी विनंती करतो की कृपया आपण आम्हाला मार्गदर्शन करा.
My esteemed brothers, Mr. Jagtap, Sister Madam Nurungi, President of the Paranda Bar Association, learned members of the Paranda Bar Association. I am thankful and overwhelmed by the warm welcome you have given by garlanding me. Some advocates from Paranda Bar Association, including the icon Khwajasaheb Bapu and others, have came to me and requested that a lecture series should be arranged so that the bar here will find insights to know the niceties, how to practice in the district and sessions court, because district and sessions court at Paranda is a newly established district and sessions court and hardly it has completed 2 to 3 years. Friends, there are various topics to be discussed, but today I am going to deal with a very important topic which is useful not only for advocates but for the judges. Generally, they have to come across day to day while functioning as a judicial officers, and it is indispensable for the lawyers. Every democratic setup is comprising of 3 important organs. That is the legislature, the executive, and the judiciary. Kaide Mandal, Karyakari Mandal, and Nyayapalika, which you call in the vernacular language. The supreme function of the legislature is to legislate the laws. Laws are passed by the parliament, that is the legislature at the union, and the state legislature, that is the Legislative Assembly and Legislative Council. The supreme function of the legislature is to legislate the laws. The laws are legislated by the legislature, but they are executed by the executive. The real executive in our country is the Prime Minister and Council of Ministers, that is the government, to which we call the government. The state legislature is comprising of the Chief Minister and his Council of Ministers, that is the government at the state level. So once laws are passed by the legislature, they are executed by the executive. But it is not a day-to-day function of the legislature to do anything to the law. Ultimately, courts have to day-to-day deal with the law. The ultimate function of the law is with the courts. The laws are tested on the anvil of the courts of law. That's why they are called as courts of law. The main function of the judiciary is to interpret the law and impart justice. Though it is none of the business of the judiciary is to legislate the laws, but laws are day to day applied by the courts of law for imparting justice. And while interpreting law, the courts lay down the law. While applying the law, courts lay down the law. So to interpret means to understand the meaning of the law. What is interpretation? To give meaning, to understand the meaning. And our today's topic is law of precedence. Today I am unfolding law of precedence before you. It is very important day to day you are citing case laws. Law of precedent is also called as judgment law. What is precedent? What is the meaning of precedent? Precedent means to set an example. To set an example for the future. So by giving judicial pronouncements, by giving judgments, courts are setting example for the future. And judgments of the superior court are binding on subordinate courts. The subordinate courts are bound by the judgments of the superior courts. It is based on the common law of England. In England, the subordinate courts are bound by the judgment of the superior courts. To set an example means precedent. To set an example means precedent in a sense that while giving judgment, you are setting a precedent. You are setting an example. And that becomes stare decisis. Stare decisis means binding effect of the precedent. It is a Latin word. It is a binding effect of precedent. Now, why for subordinate courts are bound by the judgment of the superior courts? First thing is that consistency. There must be consistency in the judgment and interpretation of the law. Two persons shall not interpret the law in their own way. Suppose one judge is giving judgment by interpreting a particular law, another judge shall also give judgment in accordance with the same interpretation. If there are different interpretations, then there will be chaos. So, if superior courts have interpreted the law in a particular way, the subordinate courts are bound by that interpretation, so that there shall be consistency. Another thing is predictability, and third thing is fairness. Judicial fairness, predictability requires that subordinate judges must be bound by judgments of the superior courts, and every precedent excludes your discretion. You cannot say that I have the discretion and I will not be bound by judgment of the superior court. You are bound by. You are bound by, you must follow judgment of the superior court. There is no go away. You cannot give side by to the judgment of the superior court. Here you cannot use your discretion. A discretionary power is different, a discretion is different, but you are bound by the judgment of the superior court. You cannot say that I will not bound by this judgment. In Great Britain, whole of the law can be declared to be null and void by the courts. In our country, our courts cannot add a single comma to the law. They have to take the law as it stands. They have to follow the law as it stands, and they cannot avoid the law as in Great Britain. Whole of the law can be declared to be null and void by the courts in Great Britain. A simple example about 498A of IPC. You see that when section 498A has been introduced to the Indian Penal Code in the year 1985, after that famous Sharad Birdichan Sarda versus State of Maharashtra case, because when Sharad Sarda's case was decided by the Supreme Court, 498A has not been introduced. She was subjected to both mental and physical torture, but 498A was not there. So he was not punished under 498A. And thereafter section 498A has been introduced. At the same time, no amendment is introduced to section 320 of the old Code of Criminal Procedure. That's why it was not included in the list of compoundable offences with the permission of the court and without the permission of the court. And that's why number of times Superior Court said that state legislature, central legislature shall make it compoundable, and to avoid that, the family shall not be spoiled. If in the heat of passion a fire is lodged, if tomorrow the couple wants to come together and lead a peaceful matrimonial life, they should have an opportunity and it shall be made compoundable. And as a wife media, we are seeing that the wife is turning hostile before the court and the matter is settled. But it is not compoundable. It is not compoundable. Why it is not compoundable? Because it is not provided under section 320 of CRPs. It is like that. But courts have to take the law as it stands, and that's why they cannot lay down the law. But while applying the law, they set precedent. Now, where is the provision that judgments of the superior courts are binding on all subordinate courts? It is Article 141 of the Constitution of India. Constitution is the supreme law of the land. It is called mother of all the laws. No law in India after Constitution, that is post-constitutional era, after 1950, shall be in violation to any of the provisions of the Constitution. It will be ultra virus. So Constitution is the mother of all laws, and under Article 141 lays down that judgments of the Honorable Supreme Court are binding on all subordinate courts in India. Then Article 142 lays down that the Supreme Court, in the larger interest for doing substantial justice, can pass any order which is in the interest of the country at large. It is Article 142. Now, under Article 141, law laid down by the Supreme Court is binding on all subordinate courts. Then how our own High Court is binding? See, one thing is that our High Court is a court of records, and all courts in the state are subordinate to the High Court. So, as High Court is having superintendence over all subordinate courts in the state, so all subordinate courts in the state are bound by the judgments of its parent High Court. So, for our purposes, Bombay High Court and its decisions are binding, because Bombay High Court is having judicial superintendence and we are subordinate to Honorable Bombay. So judgments of the Honorable Bombay High Court are binding on us. Then other high courts are having persuasive significance. When there is no judgment of Honorable Supreme Court on any particular point, there is no judgment of our own High Court on any particular point, then other high courts can be cited and other high courts can be having persuasive significance. Persuasive significance means to convince you that this is the judgment of the Gujarat High Court, Madhya Pradesh High Court, Karnataka High Court, or other high court. But at the same time, if both the high courts are cited before you, your own high court will prevail. Your own high court will prevail. Very important aspect I want to share it with you is that suppose there is a judgment of the Supreme Court and there is subsequent judgment of your own High Court, and your own High Court has appreciated or interpreted the judgment of the Supreme Court in their own language, in their own way, in their own manner, then you are bound by that interpretation of your own High Court and not of the Supreme Court. You got it? See that Supreme Court has discussed a particular law, a legal aspect, and laid down a precedent. Subsequently, your High Court has interpreted that judgment of the Supreme Court. So that interpretation is binding on you. You cannot directly interpret the judgment of the Supreme Court, but judgment of the High Court, which has interpreted the law laid down by the Supreme Court, will become binding on you. Now question comes that if there is a contrary view of two benches of the High Court, then which one will be binding? I will come to that aspect later on. That will be a query in your mind. Now, one question will also crop up in your mind. What is the position with the judgment of the Privy Council? See, Privy Council was not consisting of judges. Some members of the House of Lords. See, in India we have Lok Sabha, Rajya Sabha. In England it was House of Lords and House of Commons. Some members of the House of Lords constitute a committee, and the appeals from colonial umpires were heard by that committee of the House of Lords, and that is called as Privy Council. It was the highest court of appeal where that was British colonial empire. India was part of British colonial empire. So at that time, highest court in India was not Supreme Court, it was Federal Court, and Federal Court was at Calcutta. So appeals from Federal Court were preferred to the Privy Council. And Supreme Court was not the highest court of appeal. It is only in the post-constitutional era, after Republic, Supreme Court became the highest court of the country. But Federal Court was the highest court during British period, and appeals from Federal Court were preferred to the Privy Council. And members of the House of Lords constituted committee used to decide those appeals from the colonial empire. Once those judgments were given lot of respect, lot of regards, lot of importance, significance, and they were kept in high esteem. But now India is no more a part of British colonial empire. We are independent, we are a republic. But once we have respected those judgments, we still follow judgments of the Privy Council, but they are not having effect of a binding precedent. Now Privy Council cannot be cited as a binding judgment. It is persuasive. You may cite it, you may not cite it, you may rely on it, you may not rely on it, because India is independent and no more part of British colonial empire. But the wisdom, it is said, the Privy Council has understood the personal laws of the Muslims and the Hindus 100 times better than any other court. There is very famous judgment on legal necessity by the Privy Council in the form of Hanumana Prasad Muhammad Babui. In Hanumana Prasad versus Muhammad Babui, what is legal necessity has been explained by the Privy Council by referring to the Sanskrit text like Dharmarthe, Kutumbarthe, and Apatkale. Dharmarthe means when the legal necessity means any religious obligation like offering Shraddha to ancestral souls. Then repayment of ancestral debts. For these religious obligations, if property of the giant family is sold, it is considered to be dharmarthe. Then family liabilities, marriages of co-partners, marriages of sisters, members of the giant family, is considered to be a family need, that is kutumarthe. And apatkale, it is benefit of the state. When property is likely to be damaged, property is likely to be attached for non-payment of land revenue. Under such circumstances, property of a giant family can be sold. So under Hindu law, that ruling of Hanumana Prasad versus Muhammad Babui on the part of legal necessity and benefit of state is a torch bearer, is a landmark decision. Likewise on Waqf, there is one judgment by the Privy Council, Abdul Fatah Muhammad versus Rasamiya, in which one person said that after my death, my property shall go to my son, then to his son, then to his son. And if my great grandson born died without any issue, then this property will be dedicated and go to Waqf. So this cannot be the object of the Waqf. Waqf must be immediate dedication for the religious and charitable purposes. So on Hindu law, that Hanumana Prasad ruling is a landmark, and on Waqf, that judgment of Abdul Fatah Muhammad is a landmark. So Privy Council, though has lost its character as a binding precedent or to be governed by the principle of stare decisis, still once those judgments are respected like anything, we are still following judgments of the Privy Council. Sometimes even foreign judgments on the law of torts and others are cited before Indian courts, but they are having perceived significance. What I said that under Article 141, Supreme Court is binding. Out of judicial discipline, a judicial hierarchy, our own High Court is binding. Then other High Courts in India are having persuasive significance. You are not bound to follow other High Courts. If they are cited before you, you cannot avoid, you have to discuss it. But as judgment of the Supreme Court, as judgment of the High Court, they are having a precedence value, and that is a binding precedent. You cannot go by, and you cannot use your discretion. When law is cited, it goes, your discretion goes away. Laws are the anchors of the state, as laws are the anchors of the state. You know that when a ship is to be parked in high waters, in deep waters, that is called anchoring. It is not called parking. So while ship is in the sea and it has to stand, then it is called anchoring of the ship, not parking like vehicles. In case of plane, you are using the word with this flight and then take off like that way. So it is called anchoring. So laws are the anchors of the state because the state can function in accordance with the law. Laws are the anchors of the state. Judicial decisions are the anchors of the law. Justice P.N. Bhagwati very lucidly has explained the importance of precedent in his words. What he said, Justice P.N. Bhagwati was a former Chief Justice of India. He said that law is like a plastic in my hands. By and large, I have been able to mold it when I felt justice demanded. You see, the legislature has provided dry skeleton to the law. Skeleton sakra, halanta sakra. Dry skeleton to the law. It is the judge who fills it with blood and flesh to make it a living organism. So a dead soul can be made a man only because of the judiciary, because judiciary put soul in the law. The real law is logic. The real life of law is logic. And laws are tested in the courts of law. Superior courts apply the law and lay down justice. You know that our courts are the court of facts. Even district court is a court of facts. Maybe last court of facts. In High Court and Supreme Court, they are called as courts of law because only law points involved matters are taken up for hearing before the High Court and the Supreme Court. Now, when we are citing judgments, what precaution we have to take? And that I am coming to that aspect because that is more important for your purposes. See, we are court of facts. Firstly, we have to go by facts. So, Mufassir court lawyers or lawyers practicing in district court and taluka court have to first master facts. If you master facts, then you are very comfortable in convincing the court that these are the factual aspects and these are the real questions in controversy between the parties. What is the real questions in controversy between the parties? You know the issues in civil matters and in criminal matters, it is charge. Charge means a precise formulation of specific accusations made against a person of the case of which he has to answer. If charge is framed, accused must know what is the case against him. He must know what case he has to face, what charges he has to face, and what charge he has to answer. And here in the light of the pleadings, in civil matters, pleadings are Lakshman Rekha. You cannot go beyond the pleadings. Any evidence taken without pleading can be excluded from consideration because evidence must be strictly tailored in accordance with the pleadings. You have to substantiate your pleadings. Plaintiff, by examining the witnesses, substantiate the plaint. Defendant, by examining his witnesses, substantiate the defense. Now, what parties in civil suit requires issues. Issues are the material propositions of law and fact which are affirmed by one party and denied by another party. Material propositions of law and fact. Material propositions of law and fact. So law need not be pleaded. What you are pleading, facts you are pleading. Now when you have pleaded the facts, then go by law. Which law applies? Here your task I am explaining with the example that see, if you have certain fever, if you have any ailment, you are not directly going to the medical store, you are going to doctor and doctor prescribe you the medicine. Doctor studies only one subject of pharmacology, that is science of medicine, Aushad Shastra. But a pharmacist studies 3 years as B Farm, 2 years at least as D Farm, that is diploma in pharmacy. All he is studying is about pharmacology. Why we are not directly going to him? We are going to doctor because doctor is the only person who can decide which medicine may suit to my body, which medicine will be better for my health. Likewise, client may come, client may come and see that manayan khub kaadun there. But you must know whether he is in possession. If he is not in possession, even if he gets the degree of injunction, whether that will help him. It will be curing brain tumor headache with just painkiller. Even for sometimes he may feel relief, but it is a cancer, it is a brain tumor and he may die. So without possession, if he is getting the degree of injunction in his favor, it will be a paper degree only. So first ask him that no, first go for possession, then claim injunction, then claim declaration of ownership. When your ownership is questioned, you must claim declaration that I am the owner. If you are dispossessed, first claim possession that I may be put in possession. And then comes the question of injunction, that is restraining in peaceful possession and enjoyment of the property or infringement of your right. So first go with facts, then go with law, and third comes that to buttress your submission, to make your submission more convincing, to make your submission more acceptable, you may refer to the case law. But while citing case law, be sure that you are not restricting yourself to the just placitum. Read the whole judgment. Read the whole judgment. Sometimes such case laws are filed before the court, cited before the court, which are going against the party who is citing it. So don't just go by the placitum. You read it twice, right? And then only you feel that it is perfectly applicable to your case. It is akin to the facts of the case you are trying or you are pleading. Then you cite that judgment to make your submission more forceful, and it is said to buttress your submission means to make your submissions more convincing. What precaution you have to take while citing it? See that that judgment must not have been overruled by the superior court. Because citing overruled judgment is professional misconduct. A judge may take action against you because judge is not supposed to know that that judgment is, he must know, but he is not supposed to know in all the cases that it has been overruled. The liability is that of the advocate, that he should know that whether that judgment is overruled or not. Some judgments are stayed by the superior court. Sometimes the effect of the judgment is nullified by the superior courts. Better to avoid citing those judgments, and when certain controversies or the questions of law are not finally adjudicated and controversy is not finally set at rest. On that aspect, better to avoid citing overruled judgments or judgments where controversy is not set at rest. Likewise, for gutka consumption, 328 shall be applied or not. That controversy sometimes is not set at rest by the Supreme Court. It is the product of the mind of many superintendent of police that they are adding section 328 for consumption of gutka. So consumption and administration are two different things. Consumption means if a person is directly taking, it is called consumption. If somebody else is giving to him, it is called administration. So consumption of poison is suicide. You are taking poison of your own, it is called consumption of poison. But somebody else is giving it to you, it is called administration of poison. That may be murder if it is administered. So on this aspect, if law is not settled, better to avoid to cite those judgments. You must be very much particular that whatever you are citing to the court is applicable to you or not. You must know, just for satisfaction of the client, avoid citing judgment. Now, what is binding and where it is binding? There are kinds of judgment, then certain principles evolved, certain doctrines evolved in a judgment. See, a judgment is a judgment on the point of law and in respect of the controversy which the court is supposed to decide. There are two important doctrines and don't get it confused. I will try to make it very simple for you. It is called ratio decidendi and another is called obiter dicta. Ratio decidendi means reasons for the decision. Whenever a superior court decide any matter which they have to decide, is called ratio decidendi of the case. In simple words, you can take that reasons for decision. Ratio decidendi means reasons for decision. And another category is obiter dicta, means passing references, just side by side. Suppose in 125 matter, court has to decide whether wife is entitled for maintenance or not. And reasoning is given that she has been neglected, she has been refused to be maintained, she is unable to maintain herself, husband is having sufficient means, without any reasonable cause he has deserted her, he failed to maintain her. This court has to decide, and if court has decided that, it is called ratio decidendi of that case, because this court has to decide and court has given reasoning that why wife is entitled for maintenance and why he has granted maintenance to the wife. But while deciding that matter, if court has said that now there are rampant trend that false petitions for maintenance are being filed, prices of essential commodities have gone to the sky, it is very difficult to maintain, and if passing references are given which are not necessary for deciding that matter, that is called obiter dicta. Passing references means matter is different, and if certain observations are made, then those observations which are not touching to the matter before it and given just by say, that is called obiter dicta. Now, which is binding? Of course, ratio decidendi means reasoning for the decision are binding on the courts. Obiter dicta is not binding, but under 141 of the Constitution, even obiter dicta of the Supreme Court is binding on all subordinate courts. Because obiter dicta of the some of the judges is as important as its ratio decidendi. To name few, first and foremost in category is Justice V.R. Krishna Iyer. See, Justice Krishna Iyer's vision, his command, he was a luminary, he was a visionary, he was a legend of law, and obiter dicta of the judges like we are Krishna here, then Justice Gajendra Garkar, Justice Hidayatullah, and so many on, so many on. If that is as important as obiter dicta, then that obiter dicta of the Supreme Court is also banned. Now, other category of a judgment is judgment per incurium. Judgment per incurium means in ignorance of any statute or precedent. Suppose if the High Court has given one judgment and they are not knowing, or it is not brought to their notice that yesterday Supreme Court has passed such an order, and if that judgment is rendered without considering that judgment of the Supreme Court, this is called judgment per incurium. Suppose any new statute has been passed, any new law has been passed, and matter is filed long back, and now the court, while deciding the matter, is not knowing that particular enactment, particular statute, and if decide the matter without knowing that particular statute which has been passed or certain amendment has been made in that particular provision. For example, take for example for giving license on moped, the age is 16 years. That is amendment. But if court is not knowing that for giving license, age must be above 18, and he is not knowing that amendment and given the order that no, after 16 no learning license can also be given. If that order is passed, if the judgment is given, it is without knowing the amendment introduced to the Motor Vehicle Act. That judgment is called as judgment per incurium. Now another judgment category is judgment sub silentio. Sub silentio. Sub silentio means silent on the point of law. If suppose certain matter is argued before the court, and if any law point is involved, and if that law point is not taken into consideration while deciding that matter, and judgment is given without considering the legal aspect involved in that particular matter, it is called as judgment sub silentio. And you may come across various judgments in which certain legal aspect is not taken into consideration, and by the passage of time, the judgments are overruled because they are falling under the category of judgment sub silentio. So judgment sub silentio, which is without considering the legal aspect, are not binding. It is not a binding precedent. It is not governed by the principle of statutory. The larger bench judgments are binding on subordinate bench. Larger bench is comprising of 3 judges, 5 judges. Sometimes it is a constitutional bench. So judgment of the constitutional bench are binding on lesser bench. Judgment of division bench. Generally in Supreme Court, 2 judges are sitting. No single judge sits in the Supreme Court. So there is always division bench in the Supreme Court. So when 2 judges are sitting in the Supreme Court, it's a division bench. But in High Court, when 2 judges are sitting, it is a division bench. So judgment of the division bench is binding on single bench. Suppose there is a judgment of Nagpur bench of Bombay High Court of division bench. So that judgment is cited before you, and judgment of a single bench of Aurangabad bench is cited before you. Judgment of division bench will be binding on. But judgment of division bench of Nagpur bench is very contrary to the view taken by division bench of Aurangabad, and both are cited before a judge. Then question comes, which is binding? Your district is attached to Aurangabad bench of Bombay High Court. You, without commenting on the judgment of Nagpur bench, you have to rely on the judgment of your own nearest bench of Honorable High Court. It is like that. Now Supreme Court is bound by its own judgment, but Supreme Court has very great power or omnipotent that it can overrule its own decision. and Supreme Court in number of cases has overruled its earlier decision. Though Supreme Court is bound by its earlier decision, but at the same time, Supreme Court is that omnipotent, powerful, or having right to overrule its own discretion. So vast power of taking contrary view to the earlier decisions. As far as constitution is concerned, initially in Bedubari's case, Supreme Court has said that preamble is not the part of the constitution. Then it cannot be amended. In subsequent decisions, whether it is a part of the constitution, not part of the constitution, goes on, then A.K. Gopalan is there, then Sajjan Singh case is there, so many cases. But the landmark is the Keshwanandan Bharati versus State of Kerala. In Keshwanandan Bharati, Supreme Court has said that it is a part of the constitution. It can be amended like any other article of the constitution, any other provision of the constitution, but basic structure. Such amendment shall not touch the basic structure of the constitution. That is sovereignty, that is fundamental rights and basic structure of the constitution, where sovereignty of the citizen, the constitution and liberty of the citizen is to be protected, and without touching the fundamental rights or liberties granted by the constitution, you can amend the constitution. So Supreme Court has taken contrary view to the earlier view taken by the Supreme Court. It has overruled its own decision. So while citing precedent, you shall not go by just place it and read the whole judgment. That will provide you a lot of insight to understand whether it is applicable to your case. And we are court of facts. We are not purely courts of law. So first go by facts. Master the facts. When you are arguing any matter, if you are master of facts, you can convince the court that these are the questions involved in this particular set where controversy arises. We call in the ordinary term it to be the real questions in controversy between the parties. Where is the dispute? Where is the controversy? What issues are involved? Then see what law is applied. And then you come to the case law. Some case laws are always torch bearer, always they are the landmarks, and always they are helpful, and always they are considered to be at the pinnacle, like judgment in the case of Tehsildar Singh versus State of UP. For contradictions, omissions, it is a landmark decision. For contradictions, omissions, you have to go by Tehsildar Singh versus State of UP 1950 Supreme Court. Then many say that in Sarda's case, number of issues are involved. It is a landmark decision covering dying declaration, covering 313 of CRPC. What is not put to the accused cannot be used against him. This was laid down in the Sarda's case. Certain judgments will, of course, provide you a lot of insight. Then there is judgment of Amjad Khan versus State of UP on right of private defense. This is a landmark decision. In Constitution, there are many judgments which have changed the history of India. You take it to be a case of Maneka Gandhi, Article 21. The way in which Article 21 has been dealt with in the case of Maneka Gandhi is a landmark decision. Then ADM Jabalpur's case, the Supreme Court itself says that we have heard in considering the freedom of a person and on the doctrine of habeas corpus. So there are certain landmark judgments. The case of Nanavati, it is considered to be last trial of jury. The jury system in India has abolished after the case of Nanavati. In jury system, the whole sympathy of the jury was with Nanavati, and they say that he shall not be awarded capital punishment. His case shall fall within the grievance sudden provocation. But fortunately, it was Mr. M.C. Chagla of Bombay High Court who said that once he has fired the first round, it was okay. When he has found the second round, it was okay. But when he has fired the third round, grievance sudden provocation goes away, and it was the richest degree of culpable homicide. It was a murder. So it is certain judgments will be like Mughal Azam, Sholay and Pakiza. All the time you say, all the time you enjoy it. You read it, it is a landmark in all respect. But every day you have to read the judgment. Many judgments are creation of the creative mind of a judge. You say that every judge must have a creative mind, and some judgments are the product of the creative mind of the judge. So, when certain questions of law are discussed, you cannot just say that only that aspect is dealt. But sometimes you may come across certain cases where only for the purpose of that matter that controversy is decided, and it cannot be taken to be precedent forever. Sometimes by just reading precedent you are confused. For condonation of delay under Section 5 of Limitation Act, many judgments are coming where it is said that it is not the act of generosity, and each and every day's delay shall be explained. Each and every day's delay shall be explained, and by way of generosity, long delay shall not be condoned, and it is encouraging the scrupulous litigants to come to the court again and again, and you have to decide the still claims, the controversies which were 10 years old, 20 years old, 15 years old. Once superior courts are saying that you must clear the old pendency, and still you are restoring the suits, you are condoning the delay, you are condoning the delay of years together. So that should be discouraged. But at the same time, the Supreme Court, High Court, in number of cases said that the approach of the court while condoning delay must be pragmatic, must be liberal. Court must be liberal while condoning the delay. So two types of case laws are there. So you have to strike out a balance between the two. Some case laws say that no delay should not be condoned casually. Some say that liberal approach must be taken. So you have to find out the middle way. Suppose in 498A there is one ruling which says that independent witnesses are not required. A woman is not supposed to make her grievance public. She may not go to neighbor and will tell that what type of cruelty is meted out to her. At the same time, there are judgments that says that there is no single outsider. She has not even examined the neighbor. She has not even examined her friend to say that what type of cruelty she was subjected to. So that is there. So certain case laws, certain judgments are only restricted to the facts of that particular case. As a precedent, you cannot cite in all the cases, and they cannot become a precedent. But if certain facts are very similar to your case, very akin to the facts of your case, and you are damn sure that this ratio means what is laid down and what is binding in nature, is applicable to the case before you. You must cite with all confidence. But at the same time, you must see that what is the ratio laid down in that particular case. At the same time, if you say that your case differs in fact, if still certain legal aspects which have been considered in that particular case can be enough to convince the court to decide the issue, you may rely on that judgment. See, no two criminal cases are having similar facts. If there are repeated murders, all murders are having different facts. They differ in facts. So in criminal cases, there cannot be a binding precedent on facts. We are on the pints of law. When it is 300 and when it is 302, the thin line of difference between 304A and 300, that you have to differentiate on the point of law as per the definition of that penal enactment and not on similar facts. So facts differ from case to case, but law point involved, what ratio is laid down, that will always help. And now you will get number of case laws, how to prove dying declaration in criminal cases. But you must first know what is dying declaration. You may first know how dying declaration is given, how it is to be recorded, and then you come to the case of Kushal Rao, how to prove dying declaration and what is the position if there are more than one dying declaration. But before that, you must know word dying declaration is never used in the Indian Evidence Act. What it says, persons who cannot be called as witnesses. Under section 32, you will not find the word dying declaration. It is heading is persons who cannot be called as witnesses. Word hostile witness is nowhere used in the Indian Evidence Act or Bharatiya Sakshi Adhiniyam. It is developed on the point of case law. In Constitution, word apex court is never used. It is journalistic language that apex court is used to the Supreme Court. In entire Constitution, you will not find the word apex court. We are saying apex court. In entire Constitution, you will not get the word apex court. It is journalistic language. In the newspaper, the word apex means highest court of the country. That's why they have used the word apex court to the High Court, sorry, Supreme Court. But in Constitution, the word apex court has not been used. In Evidence Act, word hostile witness has not been used. Means allowing a person to put the questions in the nature of cross-examination under 154 of the old Act, and that is substituted by the Bharatiya Sakshi Adhiniyam. So it is very good habit to read at least one or two case law every day. So long you are practicing as a lawyer, even it is necessary for the judges that they should read the case law. They should read the case laws which are cited before them. They should also read the case laws which are not cited before them. Protocol is that when you are relying on a case law, you have to give a copy of it to another advocate. When you are relying on a particular judgment, you have to give the copy of that judgment to another advocate. So make it convenient to give copy of the judgment to another court. परंतु एखाद्या वेळी कोर्टाला स्वतःहून एखाद्या केसला टाकायचं असतं तर then what is the procedure? Court cannot suo motu put any judgment, any case law of the Superior Court, any judgment unless it is shown to the advocate who are appearing for the party. You have to show it to the advocate and say that I am relying on this judgment. What you have to say about this judgment, then only you have to cite that judgment. Because opportunity must be given to the parties to say something about the judgment. So motu, judges cannot also cite the case law. So case laws certainly provide lot of insight. They are binding in nature. They provide lot of insight in a sense that you understand that on this particular aspect of law, law is already settled, law is already set at rest, and no contrary view can be taken to the view already has been taken by the superior courts. And when superior courts have interpreted and settled any law, we call it to be a settled position of law. Why we call it to be a settled position of law? Because that position of law has already been settled by the superior court while interpreting that aspect. Then no discretion. Then no discretion. Court cannot say that, no, it is my discretion and I will decide in my own way. That's why you have every right to cite the case laws in support of your submissions. Develop a practice to read at least one or two case laws every day. Used to discuss it, how you have to interpret it, and every day be updated. And these electronic gadgets and being techno-savvy is providing a lot of assistance to you. Even nowadays, you are getting what has happened in the Supreme Court today. At 11, suppose any matter is decided by the Supreme Court, at by 11:30, you are knowing what judgment the Supreme Court has given. What High Court has decided, on the same day you are knowing what High Court has decided in particular matter. So this social media, this electronic gadgets, this computer, this iPads, and all these are so user friendly that you can be updated and you can update yourself with the law. So develop a practice. Previously, you have to wait for AIR. The paying capacity of the client at Taluk places is very low. Now the subscription of the AIR, criminal law journal, and so many journals, the lawyers at Taluk places will find it very difficult to afford for purchasing those journals because books have become that costly. But because of the Android phones, iPhones, these things have become very possible. Even at Taloha places in Marathwada, I found very rich library. They are having the collection of the All India reporters. Initially, it was in Urdu language. It used to be in Urdu language for some time. In ex-Hyderabad state, even AIR was used to be in Urdu language. Even IPC, CRPC, CPC in the ex-erstwhile Hyderabad state used to be in Urdu language, and even AIR was in Urdu language. So Nizam has taken so much pain that he has even translated encyclopedia. So judgment and hukumnama, this word is borrowed from Urdu. This hukumnama. Then purshish is a Persian word. Still we follow. Purshish means bringing any fact to the knowledge of the court in writing. It is purshish. Purshish is a Persian word. Then wakalatnama is Urdu word. Halafnama is Urdu word. Talabnama is Urdu word. Wakalatnama still we are following. So it was Zabte Faujdari, means IPC, then Code of Criminal Procedure, Zabte Diwani, Zabte Faujdari, and Tazirate into the Indian Penal Code. So AR used to come in Urdu. They have that much collection. In Supreme Court, there is one museum where judgment written in Urdu language in ex-Hyderabad state were kept in the museum. But camera is not allowed, mobile is not allowed. So he has developed that law to such an extent that even judgment of the High Court were in Urdu language. For infrastructure, we are not able to make Marathi language a language of the High Court because we lack infrastructure. We do not know all the meanings of the legal terminologies in vernacular language. Still, at district places, we are all committed to give judgment in vernacular language, and judgments are given in Marathi language also. But see that the depth required is that you must go on reading and certain legal aspect if they are settled years back, and if that is not overruled till today, it is binding. A judgment is a judgment on the facts, a judgment is a judgment on the law, but what law is enunciated in judgment is binding on all of us. If you have any query, any difficulty, any confusion in mind, most welcome. Any of you are at liberty, except senior, their presence is lot of inspiration for me. सगळे सिनियर लोक बसलेले आहे माझ्यासाठी प्रेरणा आहे. माझं काय चुकलं तर ते दुरुस्त करू शकतात, परंतु इफ यू एनी क्युरी एनी कन्फ्युजन, फक्त लाईटिंगचा मोठा शब्द वापरला म्हणून घाबरून घ्यायचं. यू मे आस्क इट. Interpretation of law means to give meaning to the law, to understand the meaning of the law. Ratio decidendi is very simple. It is reasoning for judgment. Obiter dicta, passing references. But if you hear these Latin words, you are getting confused. So don't get confused. If you have any query about law of precedent in your mind, you are most welcome. हायकोर्टाचा त्या हद्दीपर्यंत म्हणता येणार नाही, पण सुप्रीम कोर्ट इज बाइंडिंग. सुप्रीम कोर्ट इज बाइंडिंग. हायकोर्टाचं कसं आहे, इफ इट इज ऑफ that caliber or that level, you can cite it also if see these observations are made. Suppose आता 498 मध्ये असा ऑब्झर्वेशन आहे की there is misuse of provisions of 498A. The court is not supposed to decide that. If suppose a discharge petition is filed before High Court, if a discharge petition is filed under Article 482 of Constitution of India, CRP, extremely sorry. And while deciding discharge, what court has to consider? Is it necessary to proceed with the trial in this matter, or trial will be a futile exercise? हे decide करायचं आहे. Because if there is no substance in the charge, what is the point in making trial? Then court will go for discharge. So High Court has to decide only the question of whether trial is necessary or accused needs to be discharged, because there is no material for framing of charge and proceeding with the trial. Got it? So FIR has to be questioned, inherent powers have to be invoked. But while deciding that matter, High Court said that there is misuse of 498A, particularly in Marathwada region. False complaints have been filed, and we have come across number of such cases where false complaint under 498 has been filed, and all the family members of a family are made accused. This is obiter dicta. आणि नंतर एखाद्या केसमध्ये एक बाईला 50 घरचे लोकांनी मिळून त्याच्या अंगावर राखेल टाकून जाळला आणि तुम्ही ते साईट केलं. बघा, दिस इज अ रिसेंट डिसिजन when there is it is said that the provision of section 498 has been misused, whether it is a binding precedent. It is like that. So it differs in the facts of the case. It differs from facts of the case. झाला misuse झाला, this is one thing. Misuse of certain provisions of law होतो, पण there must be very genuine complaint of 498. There must be very genuine complaint of Atrocity Act. There may be many genuine complaints of certain provisions of law, not resolved. See, 353 is sometimes misused. It is a weapon in the hand of government servant. But sometimes they are beaten mercilessly. तहसीलदाराला चपला लातानी मारहाण होती तेव्हा 353 चा मिसयूज होता, एक केसला साईट करू शकतो का? When he is mercilessly beaten, so you cannot say that no, see that it is a misuse. So that is in the given facts of the case. That is in the given facts of the case. आणि superior courts are superior. They have to protect largest interest. एक शेवटचा राहून गेला, ज्युडिशियल ऍक्टिव्हिजम बद्दल गैरसमज आहे. ज्युडिशियल ऍक्टिव्हिजम म्हणजे कसं आहे, कुठल्याही त्याचे 3 ऑर्गन्स आहेत, लेजिस्लेचर, एक्झिक्युटिव्ह अँड ज्युडिशियरी. तर लेजिस्लेचरने आपलं काम करायचं, एक्झिक्युटिव्हने आपलं काम करायचं, ज्युडिशियरी हॅज टू वर्क इट्स ओन. Courts cannot make law. Courts cannot make law. Or executive cannot decide the matters. Executive cannot give the judgment, or legislature cannot decide the matter. Legislature legislates the law, executive executes it, and judiciary has to apply the law in import justice. But when 2 organs are sleeping, legislature ला त्यांचे काम माहित नाही, executive is sleeping over their functions. Ultimately, it is sledgehammer justice. And then court can say that court has used its sledgehammer justice, means it is aggressive role of judiciary, and that aggressive role of judiciary is called as judicial activism. So don't confuse judicial activism with law precedent. Judicial activism is aggressive role of judiciary, and it is invoked with writ jurisdictions under Article 32 by the Supreme Court, under Article 226 by the High Court. That's all. If you have any query in mind, otherwise, thank you.
परंडा विधिज्ञ सेवा संघ आणि तालुका सेवा संघाच्या संयुक्त विद्यमाने आज या ठिकाणी आयोजित केलेल्या काही दिवसीय शिबिरासाठी आवर्जून उपस्थित असलेले मार्गदर्शक सन्माननीय ख्वाजासाहेब यांनी अगदी एका तासामध्ये दिवाणी आणि फौजदारीच्या विविध तरतुदी आणि कायद्याचं खूप अनुभव असं मार्गदर्शन आम्हा सर्व सदस्यांना केलं. त्याबद्दल मी बारच्या वतीनं आपलं खूप खूप आभार व्यक्त करतो. यांच्या कार्यक्रमासाठी आवर्जून उपस्थित असलेले सन्माननीय जगताप साहेब आणि सन्माननीय योगेंद्र मॅडम यांचाही बारच्या वतीने मी आभार व्यक्त करतो आणि हा कार्यक्रम संपला असं जाहीर करतो.